My name is Peter Williamson. I'm a trial lawyer. I've been so for 44 plus years. My client, Serenity Sky Ramos, a 17-year-old high school student at the time, was driving with her older sister. They were driving eastbound on Highway 178 outside Bakersfield, California. And they suddenly encountered a disabled vehicle. Serenity's sister was able to slow down the vehicle. She was able to drive around the disabled vehicle, but decided that they would come to the aid of the person who they saw sitting inside the front seat of the car. It turned out that he was highly intoxicated and had been in a single vehicle accident. Serenity was standing at the front of her sister's vehicle. While she was standing there on the phone, defendant vehicle came eastbound down the highway in the number one lane at what they perceived to be an excessive rate of speed. Instead of moving to his right to get into the number three lane, which was wide open, and to go around the disabled vehicle, he actually turned to his left, thereby struck the disabled vehicle, then proceeded to strike Serenity, who was catapulted about 6 feet in the air over a guardrail, and then struck Serenity's sister's vehicle as well. The initial hurdles that we faced basically involved the drunk driver, who was ultimately arrested at the scene. And the position that the defense took immediately was that they were not responsible for this accident, that it was the drunk driver. This was a very complex accident in terms of how it occurred and the various claims that were being made. So it was very important for us to get together with DK Global to illustrate how the various impacts occurred, how the plaintiff was struck by the defendant's vehicle, and then also to devise an alternate scenario. Had the defendant driver been driving at a reasonable rate of speed, had been attentive to what was in front of him, that he could have done exactly what the plaintiff's sister did in going around the disabled vehicle and avoiding a collision altogether. So that was important to us in terms of presenting the animation at mediation. We wanted to send two messages to the defense. Number one, that we were very well prepared to try the case. And number two, we had a way to explain this accident to a jury in which they would understand that the primary responsibility for this accident was the defendant driver. The case did not settle at mediation. I sent what is called a statutory offer to compromise under California Code of Civil Procedure Section 998 to the other side for $850,000. And much to my surprise, on the very last day, the 30 days that elapsed from the date that we served that statutory offer, it was accepted by the defense. The case, however, was not settled technically. It went actually by way of judgment. A judgment was submitted to the court, signed off by the judge, and we entered that in the court record. I can explain orally how an accident happened, but if I can show it to them graphically, it's much more powerful and it's most importantly more persuasive.